Hi, and welcome to the Smart Divorce podcast. I'm delighted to be joined today by Matthew Taylor and Liza Gatrell, who are family lawyers at Stowe Family Law, the only national law firm dedicated to family matters with the UK's largest team of specialist family lawyers, crikey. These two guys also host their own amazing podcast called Stowe Talks, which is a podcast designed to support people going through relationship breakdown and all the challenges that this brings. So competition, I guess.
Friendly competition.
Friendly competition, absolutely. Thank you for joining me. We're going to talk a bit about economic abuse, and we had a bit of a natter, didn't we, Matt, when we first met on this subject?
Yeah, we did. It's really, well, firstly, thank you for having us here. Try not to think of us as competition. You've been going a bit longer than us as well. It is slightly odd being not being the host and the shoe being on the other foot. So we will have to have a revenge attack at some point and get you on our podcast so you can know what that feels like too. But yeah, I think it's a really interesting area. I think it's a real kind of growth area, a bit kind of zeitgeisty. I think maybe dig into this in a bit deeper, but there's various different forms of domestic abuse, and different ones get different attentions at different times. And I think there, for a variety of reasons, people are kind of waking up to economic abuse, and the sort of family justice system is starting to recognise it in slightly different ways. So it's a really pervasive, difficult topic. Obviously, something that you're going to be exposed to a lot in your line of work, and something increasingly that we are. And I mean, I certainly find it interesting, and I'm trying to raise my game on spotting it. I mean, I guess similar for you, Lisa. What would you say?
Yeah, absolutely. And I think clients will also come in, or they'll have family members or friends that come to the appointment with them, and they'll have read an article or seen a post on TikTok or Instagram, and it's kind of one of the things that they will also raise with us to say, we are concerned that this has been going on, and we want you to know so that you can deal with it appropriately through the divorce.
Absolutely. Do you get people coming in who you feel have been in an abusive situation, like an economically abusive situation, but actually they haven't seen the red flags yet? They're not aware that actually that's what has been going on?
Yeah, absolutely. I mean, hindsight's a wonderful thing, isn't it? It's one of those things that I think you can look back and you can see all those red flags, but actually when you're in it, it can be really difficult. And often in relationships, one party kind of takes the lead with finances, and the other party may have very little knowledge of what the finances are, let alone, and may just think, that's just normal. It's normal in a relationship that one party deals with all of that, and I'm just told what I can spend, given pocket money or whatever it is, if you like. And I think it's only when you come out the other side of that you can then start to fully appreciate, actually, I didn't have any of my own bank accounts. I didn't have control over what I was and wasn't allowed to spend. I didn't know what the family assets were. And then I think it can be really overwhelming to pick through all of that.
Yeah, definitely. I think you're absolutely right. I think that it's probably important to say that it can be a perfectly normal, perfectly functioning relationship where one person takes the lead with the money, and it doesn't necessarily mean that that's economic abuse going on. But that can be a red flag, but there are usually a number of other things going on. In any, I've said this before, but in any marriage, it's teamwork, isn't it? And there's usually one of you will take the lead on certain things and the other will take the lead on other things, and you kind of play to your strengths. But I think, it's like you say, when you haven't got a bank account, you haven't got access to your own money, you ask and you're told that it's nothing to do with you. There are other things. Matt, I think it might be useful to kind of put some definite, I'm going to put you on the spot here, to put some kind of definition behind economic abuse. Can you give us kind of a sort of overview of what it actually is?
I think it's kind of, I mean, I'm going to slightly duck this question because it is very hard to kind of explain. It's a bit like, it's a bit like an elephant, as I couldn't describe it to you exactly, but we all know when we see it. And I think what's more helpful is, rather than any kind of set definition, because there isn't particularly, to my knowledge, a sort of legal definition of it. It's more about the impact that it has and the sort of behaviours. So I think looking at the kind of behaviours are important. I think it's important to recognise, and you sort of touched on it, that there's a continuum and there's a spectrum. And that can be from, so my relationship, I do monthly spreadsheet at the start of each month and speak to my wife about it, and we tweak it and we have a look at it, and then probably ignore it for the rest of the month. But that's our approach to budgeting. And me doing that is not, I hope, and I've asked, is not financial control, because we've both got saying we've both got autonomy, and then ignore it and spend it on what we like, and we're rubbish with money anyway. What the sort of red flags of things that really, if I'm having an initial conversation with a client, making alarm bells ring for me, are things like not having a bank account, not having a bank card, having to request permission for everything, being kept secrets from, being that you said, oh, it's none of your business, I'll just deal with that. It's about not having autonomy. It is the way I look at it. Is the control of the finances is such as to prevent a person from having autonomy to do as they wish. And that's not the same as saying, well, I was emotionally controlled because my husband wouldn't agree to spending a £10,000 holiday and went to a £5,000 holiday. You do sometimes hear that. You think, well, that's not control, that's disagreement.
Yeah.
But it's literally not having the autonomy to do stuff, not having the financial wherewithal to make decisions on your own is my sort of the way I'd kind of categorize it. Lisa, have you got you probably do have a better approach to it than me, or a better definition?
No, like you say, you get a feel for it, don't you?
Yeah.
As somebody's talking, and it's not, there's so many different ways that it can come about. So, we've talked about a few, but it may be that, you have perfectly, normal conversations, if you like, in the relationship about working, about returning to work as the children get older, etc. And it may be that one party really we'll talk about, that can be perfectly normal in relationships, that one party stays at home and the other party works. But it may be that the party that's staying at home really wants to go back to work and really wants to have their own income, and they're told that they shouldn't do that and they don't need to. Don't be silly, you don't need to do that. We've managed so far, we're absolutely fine, you need to be at home. And it's that control over, it's the control over them having the ability to acquire their own finances, them having the ability to utilize or use their finances as they want to, or to maintain them as they want to. So it is quite broad, and as Matt said, I think it is more of a feeling. It's not one thing, it's lots of little things that give you this feeling that there's kind of an undercurrent of financial abuse there.
Yeah, I mean, absolutely. just to slightly contradict what I earlier said, is that there is a legal definition of economic abuse. And I was thinking, when I said that, I was like, that's not quite right, because Section 1.4 of the Domestic Abuse Act 2021 defines economic abuse as any behaviour that has a substantial adverse effect on a party's ability to acquire, use, or maintain money or other property, or obtain goods or services. So it's that substantial adverse effect. Now, that's a legal definition. I'm not sure how helpful that is on a day-to-day basis in spotting abuse, which is why I kind of looked more towards the behaviours. There is a line in a case which we'll talk about, and I mean, you're talking with lawyers, so you're going to have a little bit of case law, I'm afraid, which is deeply dull for everyone. We will try and keep it to a minimum. But it was described, the party's conduct in the case was described in that as the exploitation of a dominant position, which is the essence of all forms of abusive behaviour. So that's something common to all forms of abuse. So I think, those are a couple of definitions which might point, but they're so wide. They're so wide as to be difficult to categorise, and it comes back to the continuum in the spectrum. A substantial adverse effect on the party's ability to do those things, that can have a huge range of outcomes.
Yeah, absolutely. I think between the two of you did a really good job of financial abuse and economic abuse. So I think your examples, Matt, were perfect for financial abuse, and then the addition of Lisa's kind of covered economic abuse as well, which financial abuse is kind of part of. So I think it's kind of that, it's not just that just controlling money, but it's controlling their ability to earn as well, or their ability to gain education. So I did a course with Surviving Economic Abuse, who are a fantastic charity that I know you guys are aware of as well.
Yeah.
And their course was talking about the spouse had run down the petrol in the car because they knew that their spouse was going for a job interview, and they'd taken all the bank cards, so there's no access to money to put fuel in the car to get to the interview. And that maybe feel like an extreme example, but actually I don't think it's that extreme when we've, if you've come across that sort of abuse with clients, actually you go, yeah, I've seen that, I'm much worse.
Yeah. And it can be dozens of those sort of things every single day. It's one of the difficulties historically with how this has been catered for in particularly financial remedy proceedings following divorce, is that you are looking at such an enormous number of incidents that on their own, might not have the sort of what we call the gasp factor, might not be something horrific in and of itself, but it's that kind of that burden of hundreds and hundreds and hundreds over the course of, can be years and years and years that really build up.
Absolutely. It's that dripping tap torture, isn't it? That it's not that one instance on its own, it's the accumulation of that over and over and over again. And one of the things we want to talk about is that if you're in a situation where there's financial or economic abuse, how on earth do you get help? Because you feel like you're isolated, you haven't got access to money. You feel like if you phone a lawyer and say, I need to leave my spouse, I need to get divorced from them, you're in the wrong place, because the solicitor's going to go, right, well, I need X pounds per hour. And so how do you get the help and support that you need yourself? So do you want to give us some ideas, Liza, of where somebody can go in that situation?
Yeah, first of all, I mean, it's worth looking to see whether or not you're entitled to legal aid. It's not something that we do at Stowe, but it may well be that they are entitled to legal aid. One of the sort of hurdles for legal aid is that you are the victim of domestic abuse. And then if you don't have any of your own income, it may well be that you're able to secure legal aid to help you through the divorce process. But even putting that to one...
Sorry, I'm going to ask you loads more questions about that. You don't just get away with that.
You have to be careful, because I have to proviso that with, we don't do legal aid. No, it's not something that I've done for a good number of years. So I don't want to, I wouldn't want to go into too much as to what the eligibility criteria are.
I'm not going to ask you that. Where does somebody go to find out? Well, to find a solicitor who might do legal aid, and if so, like, how do they go about finding if they're eligible, I guess, are my questions, rather than putting you on too much on the spot.
So, I mean, I would suggest a good old Google search to begin with as to local solicitors. So solicitors local to you that do legal aid, and then I would speak to them. So speak to them. Often they will have a quick chat with you on the telephone, and they'll almost go through. I know certainly a firm that I worked for previously that did do legal aid, they would almost triage it over the telephone to be able to see whether you were likely to sort of hit that criteria for the legal aid agency. So I think it would involve just a conversation initially. If they felt like you were going to be eligible, they could then tell you what you needed to do, or what you needed to provide, and book you in for an appointment and all the rest of it.
There is also a government calculator which can give you a step through it. So it's the Check Legal Aid Service, and you can go through and you can identify the type of legal problem you have. You can go through and say it's a family problem, it's finances, whatever it may be, and it say, well, it is or it isn't available for this type of problem. This is why it might be a housing dispute. You can have a look at it and say you can get it or you can't. I've never done legal aid, so I'm not at all familiar with the provisions.
And you do have kind of the two hurdles. So you have the domestic abuse hurdle, so you have to be able to show that you're the victim of domestic abuse, which actually probably isn't as hard as it sounds, particularly if we're dealing with a case where there is financial abuse or economic abuse there. And then there's the financial criteria. So you have to show that you meet the financial eligibility, and that's not just about income, that can also be to do with capital as well. So it gets more complicated then. So it is worthwhile, using, like Matt said, using the online calculators, but also speaking to somebody that does this day in and day out, and will be able to have a much better idea of whether you fit that criteria or not.
Brilliant. Thank you. We'll put a link to that calculator in the show notes so people can find that. Sorry, I halted you in mid-flow there just to make sure that we got those questions in. So so first step, are you eligible for legal aid?
Yeah, if you're not eligible for legal aid, then it is still possible in these types of, there are applications that you could make. To put it frankly. So there is an application for interim maintenance that we can apply for. So if the vast majority of the assets and income are held by your partner and they are refusing you access to that so that you can, obtain your own legal advice. So if you can't get legal aid, or it's likely that you're not going to be eligible for legal aid, there are applications that you can make. So we often quite help clients who are in a vulnerable position financially, perhaps all of their assets or income, the matrimonial assets or income are held in their partner's name. So there are two applications that we can make in these circumstances predominantly. So the first one is for interim maintenance. So that's where one party perhaps has all of the income, and they're not making any payments to assist with outgoings of the house, food, mortgage payments, rent, whatever it is. So it's your general immediate needs. And that application is slightly different to when we're looking at long-term maintenance claims. So it is very much about immediate needs and what's required now to get us through to the end of the case, if you like. And so, we can make that application, and we can also make an application for payments towards legal fees as well. So that's a legal services provision order. So there's two applications that we can make to assist with that. But I suppose the proviso with that is that these applications are interim applications. You very much then have to make an application to court. So it removes some of the ability to do things like mediation and sort of all of the out of court options that we would usually really promote first. It very much requires an application to court. It also means that there are going to be extra hearings, because we're going to have extra hearings to decide whether or not these orders should be made. And there's an additional cost that comes with that. So it is a catch-22. That being said, if you are successful in those applications, unlike with general family applications where you both pay your own costs, with these interim applications, if you're successful, then you can often get a cost order that the other party will pay your costs as well.
Okay, I like the idea of that. That makes it sound a little bit more fair, because if you're kind of chopping off the out of court options, you already know that your costs are going to be higher than perhaps if you could stay out of court.
And I think
Matt, you look like you're itching to say something.
I think no. I think that's all exactly right, and that kind of fear of straight into court proceedings is pretty scary for people. And I think the first step before making those applications is always going to be, not always, but generally going to be writing to the other party or their lawyers and saying, look, this is what we need. You have to set out your case first. You have to say, I need X amount to pay the mortgage, the bills, blah, 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 blah. That's how much you need to pay. And you have this money, so give us the money. And if they refuse to do so unreasonably, that's when you make the court application. Something else that can be used, particularly prior to the legal services order, but also instead of interim maintenance, because you can use these to provide living costs as litigation loans. So, another way that and this is a real catch-22 point, because people don't know about this until they speak to a lawyer. But if they've got no money, they think, I can't speak to a lawyer. This is the problem. But these are something that we use quite a lot, and it can be in all sorts of cases, from small assets to big high net worth stuff. And that is where there are a number of litigation loan providers who, as a lawyer, can speak to and say, here's my case, here's what the assets are, here's my view of the range of likely outcomes at the end, here's what it's going to cost in legal fees if it goes all the way to a final hearing, which can be like an eye-watering sum, and potentially here's what my client needs on an interim basis. Will you loan that? And subject to lending criteria, you can get loans, which will then be repaid from any settlement. Now they attract interest, so it's sort of credit card levels of interest, so it's not a cheap way to borrow. That said, there's some case law which I've managed to successfully deploy a couple of times, which says, well, look, if your spouse has held money and refused to give it you to pay legal fees, and you've had to take a loan out because of that, then your spouse should bear the interest costs on that. So I've just had that successfully in the case. So because that can be a real controlling point, someone who is financially controlling. I mean, spouses hate paying the legal fees of the person who's supporting their spouse. I mean, it's the number one most hated thing, I think, but especially so when they're paying the extra charges of that. So there is stuff that can be done, and there's usually an outcome that's somewhere along the lines, unless there is, you run into difficulties if someone's squirreled assets away completely out of reach, transferred them to third parties and things. That becomes very difficult, because then it might not be attractive for a loan. The court is going to struggle to make orders that are going to be sufficient in those cases. You can get there, but you have to be quite creative, and obviously that leads to increased costs. But it's that point, is that there's normally options. Most people have got options, but most people don't always feel that they can get to that first meeting to discover what their options are.
Yeah, no, I think you're absolutely right. Just a question on that. If you're, I guess, for either for the cost order or for the litigation loans, do they go, well, you can use a lawyer, but you have to use one that costs no more than an hour or something? Are there limits to these things, or can you then choose who you want to represent you?
So with a litigation loan, it's the solicitor that has to make the application. So we have to be very careful that we're not promoting or giving any financial advice as to whether it's better to get a litigation loan, take a loan from a friend, credit card, bank loan, however you're going to do it. There are a number of companies, they're all slightly different in what they offer as far as their terms with litigation loans are concerned. And it's often best in the first step for the client to ring a couple of them and have a quick chat with them on the phone to see kind of what their terms are. But if the client then decides that they want to go ahead with a litigation loan, it is the solicitor that has to make that application on their behalf.
Okay.
So they would have picked their solicitor.
So they would have picked them first. Okay. Yeah. All right. That's good. And this, I guess, the same with the legal costs order. Is that what
legal services provision
legal
order?
Service provision. Eventually.
Yeah, I mean, something like that. Legal services order. But I think with an LSPO, there we go. What the court is looking to establish there is equality of arms. If your spouse is using a high street law firm and you are making an LSPO for your spouse to fund you to go to the toppest of the top London lawyers, the court's likely to raise eyebrows about it. It's about equality of arms. The court's also not, conversely, they're not going to say, well, your spouse has got the top lawyers in the country, you can go to someone who does a little bit of family law, but he's predominantly an immigration lawyer. They're going to try and achieve fairness, and it's going to be tailored to that particular case and the sort of the demands of that case. Okay.
And did the sorry for all the questions, but
that's what we're here for.
Yeah. Do they specify the kind of what the money is used for? Is it only for lawyers? Does it cover barristers? Does it cover court fees? Does it cover
any legal costs? Any legal costs? So any disbursements, any barristers' fees, any work that we do, it would cover all of it.
Valuation reports, if there's a company to be valued, or property or pension sharing reports. It's really for the full legal services. And as part of the application, obviously at the start of every case, we give a client a cost estimate. As part of the application, we provide our cost estimate to the litigation loan provider. You update those as you go and make sure that you're on track and that there's still headroom in the facility, all those things to keep updated. And as I say, I've also had them in a couple of cases where they will fund living expenses. And you say, well, client needs X amount per month to live on and it isn't being funded. So they say, well, fine, we can pay that out to the client, and that relieves the pressure. And what that does do is there are some extra costs of of the loans and things, but it doesn't have to save lawyers' fees. You send one letter saying you're going to pay this money or we'll get a litigation loan and claim interest on you, and if the other side come back and say we're not paying this money, you say okay, fine, and that saves like 3 months worth of legal arguing about, go on then, no, I'm not going to, well, what about this much, how about this much? You just crack on with it.
Yeah. I know, I like that. And you did mention before about potentially borrowing the money from friends or family. I know obviously that isn't an option for everybody, and in many abusive situations they've been isolated from friends and family, so that definitely isn't an option. But But if it is an option, how does that play into the divorce settlement? Because you kind of hear things about loans from family being treated differently to formal bank loans, etc. So how does that work in when you're separating the finances?
So we talk about two different types of loans. You've got hard loans and soft loans. And hard loans in family proceedings are those that are strictly legally repayable. Your mortgage, credit cards, something that if you don't pay it, you're going to have someone issue proceedings to recover. Yep. Soft loans are loans that may or may not be repayable. And the classic soft loan example is, oh, my parents just loaned me 25 grand for my legal fees and I need it back, thanks very much. And there's no documentation behind that. And they're treated very differently. So there's a case called P&Q, which is from the start of 2022, a decision of His Honour Judge Hess, which set out when the court should consider hard loans against soft loans and how they should be repayable or not. As a general rule, the court will say, if that money isn't legally recoverable, so it's not been documented, and or if the party just wouldn't do it because, if this money's recovered, you're not going to have enough money to buy your house and you're still mates with your parents, but you're still close with your parents, they're realistically not going to do it. The court might find that it's a soft loan, which can be quite harsh, because I've had clients who have borrowed huge sums of money from friends and family, and they're told at a final hearing and are warned, part of the way through, that they're probably not going to get this back. I've not long ago taken over a case which has got eye-watering legal costs, and it's come to me fairly late in the day, and I don't think the monies that have been advanced for that by my clients' friends and family are strictly going to be repayable. And it's really horrible news to have to say that. So our advice if someone is thinking about borrowing from friends and family is to enter into some sort of formal loan agreement, or prior to making, so I'm doing a case at the moment when a client is needing a bit of cash to fund the last bit. There's plenty of money in the equity in the house, but there's no ready cash. So she would be a good litigation loan candidate, but she will not carry the interest. So there will be a letter going off to the husband saying, look, a friend has offered to loan X, confirm that you will agree that loan gets repaid. If you don't confirm that, we'll go for a litigation loan that's got interest and we'll try and charge that to you. So then the husband is left to decide, am I going to agree? In which case will we say, well, that's agreed, so it's locked in, or not. So you just need to be a bit strategic in the way you go about it. Formal loan documentation, agreements in correspondence, that sort of thing can really help, because there are lots of people who can come a cropper with these soft loans, and then you come up against the legal obligation to repay, which may not exist, but the moral obligation to repay those monies is huge. You can't borrow 10 grand off a friend and not expect your friend to want it back. People need that money.
Yeah, absolutely. No, totally agree. Okay, so we've found out how to get some representation and be properly supported through the process. What banana skins are we going to come across through the process if we've been in a situation where there's been economic abuse? So I'll come to you first, Lisa.
So I think often it's just the hiding of if you don't know what the assets are, even when you get that Form E disclosure, so the financial disclosure, so the bank statements, the company accounts, all of that type of stuff, you don't necessarily know what might be missing because you've had no idea throughout the relationship whether there was bank accounts with NatWest, Nationwide, Barclays, and so it might look all very lovely and put together and completely normal, and you have to really then dig deep into those accounts to see if there are transactions perhaps going out to another account that give you kind of a peephole into what might actually be going on behind the scenes.
Yeah.
The other ones that we tend to get are, and it seems to be quite a big problem, is people taking out cards in their partner's names. So credit cards and loans, it's so easy to make these applications online these days, that as long as you've got your partner's information, suddenly it's like, oh, I didn't realize all those debts were in my name. Or if you're in a relationship and it's just like, oh, they just asked me to sign and they said it was to do with mortgage, and so I've signed it. And suddenly it can come out, as far as banana skins are concerned, it can come out that there's a huge amount of debt that was in the client's name that they didn't know about. And it's then trying to manage all of that.
Yeah, absolutely. How's that dealt with then? because it must be very difficult to prove you didn't know anything about it if it's in, you know,
I think
what's
that
in
is
your
the problem.
name.
I think that's the problem, though, isn't it? Is that often it's how do you prove that you aren't the one that pressed the button on the internet application? How do you prove that you were told that the document was something that it wasn't when you signed it? And often we are stuck with those debts being in that person's name, and we just have to resolve that within the overall settlement.
Yeah, it's really terrifying, isn't it? Matt, are there any other situations in cases that you've dealt with? I know you talked at the beginning of our conversation today about a case that was it from last year that was quite high profile in this sort of area.
Yeah, absolutely. And I think one of the sort of I mean, a couple of big banana skins are transfer of assets and dissipating assets, and someone transferring shares in the family company into someone else's name, or transferring property, and clients not realizing that and saying, oh, I know he's got this company, and then you realize that a year ago shares were transferred out, and that's sort of one thing that can come out, and there are ways of dealing with that. And historically, that's been the sort of financial shenanigans that, you know, that may amount to financial abuse. Yeah, a bit of shenanigans that can amount to abusive behaviour that the court can kind of readily address, because it can look at individual transactions. So these big ticket items, and say, well, that should be reversed. It's called an add-back argument, or it's called you make what's called you make an injunction application to have these transitions set aside, dispositions set aside, and they're quite easy to identify. Not necessarily easy to get set aside, but to identify. And if you can kind of establish what has become called the gasp factor, then you can have that taken into account in proceedings. What is a lot harder, and this is starting to change, is those we're talking about, the kind of water torture, kind of drop, and you're not looking at an individual 50 grand that was transferred to someone's brother to hold, and therefore that should be put back in the pot. What you're looking at is a series of transactions that amount to financial control and economic abuse. And there was a case at the start of the year, which is called BP and EP, which is the first reported case from a circuit judge, Judge Reardon, where, just very briefly, there were a number of these big ticket transactions in that case, and they were all reversed and set aside because they all hit the gas factor. But in that case, which is quite unique facts, it was the wife who was found to be the abusive one, and the husband in that case was illiterate. And what the wife had been doing, basically taking advantage of the husband by controlling things. This is where the phrase, the exploitation of a dominant position came about. And the fact the husband was unaware throughout the marriage that the wife had done this, and she was able to control it. She took advantage of his situation. And in doing that, and the judge taking a view of the circumstances and saying that, you know, here, this does have this gas factor, which has been required previously because of the illiteracy, and it's quite stark findings, as well as reversing those individual transactions. Once she'd done that, she then had a general adjustment from sort of 50% to 52%, which doesn't sound a lot, but it was quite a reasonable sum of money, to then give the husband a bit more, to kind of cater the fact, well, look, there has been abusive behaviour. It's probably led to some of the loss of assets I can't quite identify, but that behaviour is reflected. And that's really the first time that that's been taken into account. And what she says in that judgment was saying that, look, not all cases involving economic abuse will have the gas factor. This one does, but I don't think it all has to. And I think, the banana skins, to go back to, your phrase, the banana skin is you come out and just money has sort of tripped away and there isn't money there, and you have a client who's sitting there looking like, well, I thought we were okay, we live in this nice big house and the kids have gone to private school, and where's it all gone? And in those circumstances, if you can establish a pattern behaviour, you can now sort of rely on this case, and there will be, I think, continuing developments off the back of this judgment and similar judgments when the court really refines its position in a bit more detail. There will be at some point a Court of Appeal decision, which will be, this isn't precedent forming because this is the first instance decision, but the Court of Appeal will, I'm sure, grapple with this and try and, now that there is a wider understanding of the nature of financial and economic abuse, look at in what cases should we talk about conduct arguments in financial remedy proceedings, and the phrase is conduct such as would be inequitable disregard in brilliant 1970s statutory language. But reaching that threshold of inequitable disregard, things have changed over time because it's affected by what is seen as societally acceptable. And there will be more cases, I think, to develop that. But I think there is kind of some hope for victims of financial abuse that the court is now starting to be more prepared to recognise that, okay, you don't have to just say, well, this property was bought in place in the name of someone else. You can say, well, in general, throughout the marriage, there's been such a control and dominant abuse of a dominant position in respect to the finances that actually there should be more general adjustment in my favour because it's had a negative financial impact on me.
Yeah, I think it's really difficult though as well because, you know, we talk about needs trumps all, and often whether or not the court can, you know, you have a moral argument as to whether conduct should be taken into account, and then we have the everyday practical what's available for distribution. And it can be really, really difficult because ultimately, you know, the courts do have, it's the Matrimonial Causes Act, section 25, we have criteria that we have to take into account. We're looking at what would be a fair settlement. Conduct is one of those criteria. But for the vast majority of cases, we need to meet basic needs. So we need to ensure that both parties are housed. We need to ensure that both parties have a reasonable income to, you know, meet their monthly outgoings, and pension resources from the assets of the marriage. And actually, for the vast majority of cases, there's only just enough money to do that. And so then for the courts to then start penalising for conduct may result in one party not being able to house or meet their monthly outgoings. And in circumstances like that, you know, the courts needs trumps everything. And the courts might recognise that the behaviour was poor, but may not be willing to go that step in penalising that person financially, if it's going to have such a fundamental impact on the ground. And I guess that's one of the things where it feels unfair sometimes that, okay, if we had X number of assets, that would be taken into account. But because we've only got this, that's not going to be taken into account. And that can be really, really difficult, particularly for clients in lower asset cases, to juggle with, because actually, you know, we often, when we're looking at, for example, amounts in bank statements being transferred out, it's not uncommon for judges to say, I am not going to look at anything that's less than £500. Now, £500 as a single transaction in a multi-million pound case is a drop in the water. But £500 in a single transaction for a couple that are earning £15,000 each and have a house that's valued at 300,000 is a huge amount of money. And again, these cases are really difficult for that reason. And we do often have to take a bit of a broad brush approach because legal costs escalate significantly if we start looking into every little thing. And it's about weighing up that cost benefit analysis all the time, which is why, as I say, I think these cases are so difficult.
Yeah, and I think that the actual the structure of financial remedy cases as well, which I'm sure your listeners will be familiar with, is that there are essentially 3 hearings, and most cases settle at the second hearing. And it's very, very expensive to run to a final hearing. And if you want to get findings that there has been economically abusive behaviour to such a degree that it should be reflective in a substantive award, then you either settle on that basis, and logically, if there is an abusive personality, then they're not going to be willing to settle on that basis because they're abusive. So you've got to run it all the way to a final hearing, which is expensive, costly, and risk-laden because there's always risk in litigation. So you have to be really very confident that it's worth doing that there is that cost benefit analysis pays off, and that you've got the available funds to do it and it's proportionate to the overall assets, and you're still going to be able to meet someone's needs. So you've got quite a convoluted kind of multi-wheeled Venn diagram going on there to get to a point where you can run that argument. It's getting easier, certainly, but it's still, you know, it may sound quite callous, or it may sound quite hard-nosed, but I have said to clients before, I just don't think you should run this. I think you're right. I think morally you're right, but legally and cost-wise, I can't advise you to spend this money on us. which might sound a bit like not fighting a corner, but you've got to give that advice and be absolutely realistic. And you don't want to be throwing good money after bad.
Yeah, and sometimes it's better actually to get a settlement that meets your needs, to split those finances off, have that control, and perhaps get some education, speak to a financial advisor, because often clients in these circumstances don't know what options are available, as far as they might not, they aren't the ones that have dealt with the mortgages, they aren't the ones that have opened savings accounts or investments, etc. So the best thing that they can do is set themselves up now to move forward and educate themselves moving forward, rather than potentially spending tens of thousands of pounds on a final hearing to get those findings. But it is really difficult, because you feel for clients, and we all know what's morally right and wrong in circumstances, but it's definitely having to make that difficult decision as to what's right for that person so that they can move forward.
Yeah, no, absolutely. I think it is important to say that the economic abuse it's not only affecting people who are at the lower end of the scale. It is literally right across the board, from your wealthiest right to the ones who, and there are considerations in all cases depending on as you say, the costs as well as everything else. I feel awful doing this, because I really could have this conversation for very much longer, but we've kind of come to the end of our time together. So just before we say goodbye, any last thoughts that you think are important for us to get out there in the wider world? Shall I start with you, Lisa?
Do you mean from a divorce perspective, or anybody that feels that they might just be in this financial?
Yeah, from a divorce perspective, I think.
I think it's find your support network. So, get some legal advice, but also speak to a financial advisor, have a friend or a trusted person that you can also talk to, because like you rightly say, people that are in these circumstances have often, may have lost contact with lots of family and friends, and they are going to need that support. So I think that's almost, they need to educate themselves on what's going to be involved in the divorce, but also what's going to be involved in rebuilding their finances, moving on from the divorce, and also getting that emotional support. So yeah, find your network and build your network.
Perfect. Thank you. I wholeheartedly agree with that. Matt, anything from you?
I think if anyone's listening to this and thinking, crikey, that's me, and how am I going to help get help, or crikey, that's a friend, how can I help them? I think the first thing that can be done that doesn't have an immediate cost is educating yourself a little bit. So listening to this has been a great start, but there are plenty of other resources online that can help you prepare yourself and be as smart as you can, and then that can lead you to finding a lawyer who will do a free initial meeting. Go through the legal aid thing. There are loads of resources. I'm going to shamelessly plug the Stowe support website, which houses all Stowe Family Law's myriad blogs and webinars and podcasts and things where we talk about abusive behaviours a lot. And that's the other thing, is to recognise that economic abuse often comes hand in hand with physical abuse or emotional abuse, or abuse of the children, or whatever it may be. So you can educate yourself and do your prep quietly and get ready. And then when you speak to, hopefully get in the position where you're going into the lawyer, and then you can say to a lawyer in the first meeting, in a half-hour free call, whatever it may be, I've got concerns about my funding. Here's my asset position. Do you think we can get anything? And then you can cut straight to the chase, and the lawyer can say, yes, I can, or I can't, but I know a lawyer who can, because most lawyers will refer on to friendly contacts who can do it. So I think it's that self-education piece which can give an abuse victim the confidence to then take the next steps.
Absolutely. I totally agree. And on the subject of free stuff that's available, our website has loads of blogs. Similarly, also, season 4, episode 14 with Dr. Sharps-Jeffs of Surviving Economic Abuse. Season 4, episode 14 with Rosie Lyons talking about money issues and abusive relationships. And season 4, episode 13 with Dr. Supriya McKenna on divorcing a narcissist. Can't speak anymore. So it just remains for me to say thank you to Matt and Lisa for joining me today. It's been a fantastic episode. I hope you'll join us next time. Thank you.